Good morning and welcome to our November 20th public hearing. We have several items on our public hearing today. One of our first item is ADM file number 2022-12. This is a proposed amendment of MCR 7.118 that would clarify access to and service of certain records for parole board appeals. And I believe we have one speaker, Maya Menlo from the State Appellate Defender Office.
Good morning, Your Honors. May it please the court, Maya Menlo of the State Appellate Defender Office. I'm here today, as the Chief Justice said, to offer comment in support of the proposed change to MCR 7.118. I'll be brief and want to make sure I answer any of the questions the court may have, so please interrupt me at any time. I first want to mention that in the language published by the court, there is one small piece missing, and I'm looking at F1, and this relates to the application that is filed by, in this case, either a prosecutor or a victim. And so just wanted to flag that for the court that it's not just the prosecutor that can file an application for leave to appeal the parole board's decision. It's also the victim. And we would ask that the rule that provides additional information to counsel for the appellee apply both in cases of a prosecutor's application and in cases of a victim's application. And so again, that's F1 that currently reads within 14 days of being served with a prosecutor's application for leave to appeal. We would ask that perhaps prosecutor just be removed so that this rule would apply to any application for leave to appeal. Moving on from that, broadly speaking, the reason that we support this proposed change is because it will provide important information to counsel for an appellee. That's somebody who has been granted parole and, again, a victim or a prosecutor has taken an appeal. At the application stage currently, there's a real gap in information. Oftentimes the prosecutor or the victim, whoever's filed the application, will have more information than counsel for the appellee. And part of that's just because they have filed the application and we are coming in response to their filing. But oftentimes there's been some history where the counsel for the other party has built up records, information. They've gotten MDOC records through prior proceedings or through the instant proceeding, and then we don't have access to any of that material. So this would cure that problem, and it would make it a lot more fair for the appellee who, again, has been granted the parole. We know that the parole board is due a lot of deference, and we are in the position often of representing these individuals without the full information that we need. And having been in this position, I can say that it sort of feels like walking into a preliminary examination without discovery, which we all know would be unacceptable. And so we're asking this court to make that change. I'm happy to answer any questions.
There was strong opposition from our Attorney General. Do you want to respond to that opposition?
Well, Your Honor, I don't know how much time I have left, and I'd like to pull up the comment here.
Well, that's okay if you're out of time. If you don't, I'll give you a minute, or if the chief will give you a minute.
Yeah, you have plenty of time to respond to Justice Sara's question.
Okay, thank you. So while I'm pulling up here the comment by the Attorney General, I would just note that the process of providing access to information already happens. It's just that it happens later in the game. So when an application is filed, there's not information that's provided, or it's very, very little. It's already contained within the rule. It's a few documents, like maybe 5 to 10 pages in any given case, not nearly enough to actually respond to the substance of the application. But if the application is granted, which very often is accompanied by a stay of the parole, which means that the individual is serving additional time in prison while the application pens through the circuit court and then sometimes, up to the Court of Appeals or this court, then there is, I'll say discovery, but it's then the MDOC records, then the other material is provided. So there's already a mechanism for doing that. And we are simply asking that occur prior to a circuit court making a decision whether to grant an application, because very often we can make an excellent argument that the parole board's decision was within its discretion before the circuit court even grants an application. So to be in a situation where we are without full information and the circuit court has granted an application that then prolongs our client's time in prison, it really sounds in a due process violation. So the timing of the provision of information really matters. And that's why we're asking that this be provided earlier rather than later.
Given the very high level of deference that's given to the parole board, and I think the case law that comes from our court supporting that high level of deference, how often is it that we actually see that stay? That will result in more time, and then at that point you get the information that might clarify that it was within the discretion.
I would say, and this is anecdotal, of course, almost always. If the court is going to grant the application, the court will almost always grant a stay. Because at that point, the circuit court has some idea from reading, again, the prosecutor's application, the victim's application, which is informed by the record. Our response, unfortunately, is not going to be as well informed by the record because we don't have it. The circuit court has determined that something needs to be reviewed in the parole board's decision. And we see the circuit court applying that same logic to prosecutors or victims' requests for a stay. And so I've never, in my, again, limited experience, although I have handled a number of these and others at Sado have too, we've never seen a client, for example, released on parole and then the parole appeal process continues. I'm aware of one case where that occurred, but it wasn't one.
No, I misstated my question. It really was about how often that the application will delay the process, given that the initial question is there's tremendous discretion given to the parole board. Is there enough even here to proceed further?
Okay, I understand the court's question to be that does the filing of an application sometimes often never delay the individual's
Yes, that's the question.
The answer is yes, and often for years, because the circuit court in some scenarios, and this court has seen some recently, there's the Inbrain McBrayer case, but there's others where this court has remanded to the Court of Appeals as on leave granted. In all of those cases that I'm aware of, the individual was granted parole, and then years elapsed between when the prosecutor or victim appealed the parole and when they were ultimately released because the appeal failed. But the appeal went through, multiple stages of litigation before they were ultimately released. So the application stage for that reason is quite important because we have the opportunity then to hopefully, in our view, adequately respond to the prosecutor's application, potentially defeat it, and then the individual could be released.
Thank you.
Certainly. Thank you. I appreciate the court's time.
Thank you. Any other questions? Okay, thank you. And I see we have another speaker signed up. Is that speaker Ms. Sims available? Mr. Sims?
No other speakers are here.
No other speakers. Okay, that concludes our public hearing for today, and the court is adjourned. Thank you.